Hi, I'm Mandy Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer, and today's video is another from our legal hotline mailbag. And this question is fairly complicated, so I'm going to tell you about it instead of reading it to you. In this transaction, the buyer is purchasing property from an investor landlord. And the buyer asks the question through the brokers, of course, the communications are going through the brokers. The buyer asks the question, did the prior tenant die in the house? Somehow or another they had reason to believe that the prior tenant had died in the house. And the listing broker's response was very slow in coming back, and the listing broker gave the impression that they were withholding the answer. Finally, the answer did come back that yes, the prior tenant had died in the house. By this point in time, the buyer is upset, and we don't know any more of the facts as to why, except that the buyer is upset with the listing broker for taking so long and appearing to be evasive in arriving at that answer. And so the buyer decides that the buyer is going to terminate the purchase and sale agreement using the buyer's inspection contingency, marks the box on the Form 35R to terminate the agreement, earnest money will be refunded to the buyer, signs it, buyer broker timely delivers that Form 35R back to the listing firm. And on the Form 35R, the buyer broker writes, I don't know if it's on buyer's behalf or of their own volition, but the buyer broker writes, buyer is terminating the purchase and sale agreement because listing broker's answers were evasive, or something along those lines, that buyer was unhappy with the listing broker's performance in this transaction, and that's why the buyer was terminating. So that goes over to the listing firm. Listing firm is unhappy, of course. Listing firm designated broker calls buyer broker's firm and says, we're not presenting this Form 35R to the seller. In fact, we're rejecting it because we're not going to present this Form 35R with this derogatory language about the listing broker. The buyer's firm's designated broker intercepts this call or gets this call back and says, let me look at the Form 35R, I'll get back to you. Sure enough, the designated broker is also unhappy with the way that the Form 35R was written, and assures the listing firm's designated broker that there's an agreement by the two designated brokers, the form shouldn't have been written this way, and it shouldn't be presented to the seller. And in fact, the buyer broker's designated broker says, just withhold that Form 35R, don't move forward with it. Because I'm pretty sure that when cooler heads prevail, buyer's gonna wanna buy this house anyhow. So there's some discussion, maybe even agreement along those lines. Now, fast forward to 2 days later, and sure enough, buyer does want to proceed with the purchase of the property. And so the designated broker gets back in touch with the listing firm's designated broker and says, yep, just ignore that Form 35R, buyer wants to close the transaction. Listing firm's DB is now concerned because there is this seemingly bad blood between the two brokers and maybe the buyer and the listing broker. And so there's some hemming and hawing on the listing firm's side. And then sure enough, the next day, the Form 35R comes back from the listing firm, signed by the seller, delivered to the buyer broker's firm. And so the question, of course, from the buyer broker's firm is, could they do that? Is this transaction really terminated? Doesn't the buyer have the right to proceed? We withdrew the Form 35R, all of those questions. If you want to think about this question or discuss it in your firm before I give you my answer, push the pause button. This question gives us so many things to discuss and so many learning opportunities, so let's get going. With respect to the Form 35R and the delivery of the notice of termination, I want you to think about the impact on the transaction when a buyer marks the box on Form 35R that says the transaction is terminated, the earnest money shall be refunded to buyer, and timely delivers that signed Form 35R to the listing broker. What is the effect of the delivery of that notice? The effect is that the transaction is terminated. It's gone. It no longer exists. The buyer effectively terminated this transaction by timely delivering that signed notice. There's nothing that buyer can do at this point to hang on to the transaction, it's already terminated. There's nothing seller can do at this point to hang on to the transaction, it's already terminated, unless the two parties want to come together and revive the purchase and sale agreement. But if they don't come together and revive the purchase and sale agreement, the transaction is dead. With that said, does the listing firm have any ability to reject the Form 35R or to choose not to present it to the seller? And the answer is, of course not. In fact, the listing broker is bound by the agency law, and the agency law makes very clear that every broker must timely deliver all written offers and other written communications to and from the parties. This notice of termination pursuant to the inspection contingency is a written communication from buyer to seller terminating the transaction. Listing firm has no option to withhold or reject that Form 35R. Listing firm's only option, no discretion allowed, only option is to timely deliver that notice to the seller. And the seller needs this information because the seller needs to know that their transaction has been terminated. They need to move on to another buyer or move on to marketing the property again. What about the way in which the Form 35R was filled out? If buyer terminates the agreement, should buyer broker identify the reason buyer is terminating? Answer, absolutely not. There's not even a space on the Form 35R to do that. Why buyer wants to terminate? Wholly irrelevant. Buyer can terminate for any reason or no reason at all, as long as buyer timely terminates based on the inspection contingency. So buyer brokers, you shouldn't be giving a reason why buyer is terminating, even if the reason is related to some condition of the property. You shouldn't be giving a reason why the buyer is terminating. Buyer's either in or out, and if they're out, have them sign the Form 35R terminating the agreement, timely deliver it, and let the buyer move on and let the seller move on. All of that leads to a more fundamental question, and that is, what really happened in this situation? Because we had a seller who wanted to sell the property to this buyer. They entered an agreement. We had a buyer who wanted to purchase the property, not only at the time they reached mutual acceptance, but then 2 days later after they terminated, they still really did want to buy the property. So how did we get to the moment where we had this passionate expression by the buyer or the buyer's broker that led to the unfortunate termination of this agreement? I don't know what happened. None of us know what happened. But here's what I'm betting happened. I'm betting that when the listing broker didn't deliver an immediate response to this question, the buyer broker and the buyer put their heads together and decided that there was something wrong with this listing broker, or that there was anger that should be directed towards this listing broker. Brokers, you set the tone in a transaction. This buyer broker could have just as easily helped the buyer to understand that maybe this listing broker didn't know the answer to the question and had to talk to the seller, the landlord, find out what happened with the prior tenant. Maybe the listing broker was proceeding in good faith. Maybe their communication came out awkwardly. Maybe they were having a bad communication day. Or maybe the listing broker was being evasive. Maybe the listing broker didn't want to communicate the information and didn't know how to deliver bad news. I don't know. But buyer broker, what's the tone that you set with your buyer with respect to this happening? If you get together with your buyer and say, oh, that dirty, rotten scoundrel of a listing broker, what impression is the buyer going to have of the listing broker? And if you carry that out to the seller, what impression is the buyer going to have of the seller? Remember that our industry, before I get off of that, listing broker, we don't know what happened behind the scenes of the listing broker. Was listing broker, in fact, trying to be evasive? If so, listing brokers, if you have bad news about a property that is likely to have to be delivered at some point, figure out how you're going to deliver that news so that you're not caught unawares when the question is asked, because the question's likely to be asked. You don't want to appear evasive. Nobody wants to be working with a broker on the other side of the transaction that they can't trust. So brokers, remember that our industry is based on cooperating brokers. That's why we have cooperating office compensation. It's not an industry built on adversarial brokers. As an industry, we need to figure out how to set a tone in a transaction that leads to the objective of both parties. And the objective of parties when they enter a contract is to reach closing table. And the tone that you as a broker set in a transaction to work with the broker on the other side of the transaction and the party on the other side of the transaction, in many, many cases will dictate whether or not you ever get to the closing table, and if you do, the feelings between the parties at the time they get to the closing table. And parties that get to the closing table in a cooperative manner are far more likely to move forward after closing, avoiding post-closing litigation. Brokers, take the opportunity in every transaction to trust the broker on the other side until they prove themselves untrustworthy, to think the best of the broker on the other side until you have to take defensive actions on behalf of your client. Do your best to cooperate, return phone calls, return text messages, return emails, supply information that's asked. It might not only be buyer asking questions about the seller, but maybe the seller asking questions about the buyer's financial status or the status of their loan. When you're asked questions, get the information back to the broker on the other side of the transaction. That's how you cooperate. That's how you set a quality tone in a transaction. And when you have something to say about the broker on the other side of the transaction, be careful of the words and the tone that you use, because you might create a transaction that either succeeds or fails based on the tone that you set. Okay, that's the end of my soapbox. Thank you for being a Washington REALTORS member. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org. Thank you.